I always talk about probate avoidance, and people often take that advice to heart and try the do it yourself trick to avoiding probate on their house. So, what do? Well, I'll tell you. They transfer their home into their child's name or add their child to their existing deed in an attempt to avoid probate. And congratulations, you have most probably avoided probate if you did the deed correctly. However, you may not have thought through the entire transaction because there is a multitude of things, at least here in Florida, that can become problematic when you add someone to your home or transfer it outright into someone else's name. First of all, the real property ad valorem tax exemptions that you get as a homeowner here in Florida typically have a cap of about 3% per year. So if you've owned your house for 20, 30, 40 years, you are probably paying property taxes on a significantly smaller valuation, lower valuation than what the property is really worth. And when you tinker with that by transferring property to another person, they get repriced to fair market value, which means they will get oftentimes a 3, 4, or 5 times increase on the property taxes. Secondly, if your person that you are adding to your home or transferring your property to, if they file for bankruptcy, if they get sued, if they get divorced, then their creditors could absolutely attack your home, and then you'll have to hire an attorney and try to defend it. You might be successful, you might not be, but that's not the point. You don't want to have to fight the battle. The final thing that I want to talk about is the step up in basis after you pass away. If you add someone to your home title or deed or gift it to them during life, they take what's called a transferred basis, which means if you bought it 30 years ago for hundreds of thousands of dollars less than it's worth now, when they sell it after you die, they very well could be paying capital gains income taxes at 15 or 20% on the majority of that sales price. If you do things properly and you put it in a trust or even leave it in a will, which I don't recommend because that still goes through probate, but if you put it in a trust or do a ladybird deed, you can accomplish the goals of probate avoidance. You can get a step up in basis for tax purposes, which will help your beneficiaries on their income tax bill. And you can protect yourself from your beneficiaries, creditors, predators, and other mean people, including a potential future ex-spouse. So I appreciate the thought of wanting to avoid probate, but do it the right way, do it with an attorney, and don't try to do it yourself. Have a great day.